all rise, please? The Honorable John Phipps McCullough, Senior Judge, United States District Court, Western District of Tennessee. The Honorable Samuel Hardy Mays, United States District Court, Western District of Tennessee. The Honorable S. Thomas Anderson, United States District Judge, Western District of Tennessee. The Honorable John T. Fowlkes, United States District Judge, Western District of Tennessee. The Honorable J. Breen, Chief Judge, United States, Western District of Tennessee. I think that covers everybody. God bless the United States and this honorable court. You may be seated.
Thank you, Linda. It's a pleasure to be here today in this historic courtroom with some of our judges looking at us from the back of the room, as well as this part of the room. You know, we all start at the same place most of the time, which is we start with the Constitution of the United States or its amendments. So this program, in most respects, is about the Sixth Amendment. And it's about the last sentence, or the last full phrase in the Sixth Amendment. Of course, it starts out, in all criminal proceedings, the accused shall enjoy, and it lists rights. At the end it says, and have the assistance of counsel for his defense. That was not always the case in the states, and it took a number of years, until 1963, for that to change. Although in many of the states it had already changed. In fact, the tide of history was moving in favor of what would be then an essentially unanimous Gideon decision. At the beginning, however, I want to thank my friend and all of your friend, and that is the federal defender, Doris Randall Holt, for inviting me to make very brief opening remarks so I could then return to court today. Secondly, I want to thank each of you, including all of the federal, and there may well be, and I think are, some state public defenders, as well as members of the CJA panel, both for being here today and for the service that you provide in implementing the mandate of Gideon and the Criminal Justice Act. You have made those two events a reality. It is your skill and dedication, it is your effective representation, in fact, that allows thousands of individuals who are accused of a crime to have a fair trial. When Clarence Earl Gideon stood before a trial judge in the state of Florida and requested the appointment of an attorney to represent him on the charge of breaking and entering a pool room with intent to commit a misdemeanor, which was in fact a felony, the Florida judge replied, "Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. Today you will relive with my colleagues and some assistants the events that followed, and will celebrate the decision of the majority as written by Justice Black, as well as the concurrences of Justices Douglas, Clark, and Harlan. The Gideon decision did not answer all of the questions regarding the implementation of the right to counsel in each of the states. That would take time and other cases, but it conclusively ended the fair trial doctrine that preceded Gideon in Betts versus Brady. In 1938, in Johnson versus Zurst, the Supreme Court had already held that the Sixth Amendment required the appointment of counsel or an intelligent waiver of that right in all federal criminal trials. Gideon extended that right to state criminal proceedings. Gideon was promptly followed in 1964 by the enactment by Congress of the Criminal Justice Act, obligating federal courts to pay appointed counsel in federal criminal cases for the services that they provide. Today, more than 80% of the defendants charged with federal crimes require court-appointed counsel. Approximately 2/3 of those defendants are represented by federal public defenders or defender organizations, and 1/3 are represented by CJA panel attorneys. Over $1 billion is allocated annually to pay for those appointments. While there will always be more to do, we can take some satisfaction and pride in the fact that in this country, in 1963 and 1964, the court and the Congress took two giant steps on the path to a genuinely fair system of administering criminal law. Again, I have to go to court, but thank you for allowing me to make very brief opening remarks, and thank you for making defendant representation a reality. Thank you all.
It was 1963 when Clarence Earl Gideon's case came before the Supreme Court of the United States.
Clarence Earl Gideon was an unlikely hero. He was a man with an 8th grade education who ran away from home when he was in middle school. He spent much of his early adult life as a drifter, spending time in and out of prisons for nonviolent crime.
I appreciate it. Thank you.
Gideon was charged with breaking and entering with the intent to commit a misdemeanor, which is a felony under Florida law. At trial, Gideon appeared in court without an attorney. In open court, he asked the judge to appoint counsel for him because he could not afford an attorney. The trial judge denied Gideon's request because Florida law only permitted appointment of counsel for per defendants charged with capital offenses. At trial, Gideon represented himself. He made an opening statement to the jury, cross-examined the prosecution's witnesses, presented witnesses in his own defense, declined to testify himself, and made arguments emphasizing his innocence. Despite his efforts, the jury found Gideon guilty, and he was sentenced to 5 years imprisonment. Gideon sought relief from his conviction by filing a petition for writ of habeas corpus in the Florida Supreme Court. In his petition, Gideon challenged his conviction and sentence on the grounds that the trial judge's refusal to appoint counsel violated Gideon's constitutional rights. The Florida Supreme Court denied Gideon's petition. Gideon next filed a handwritten petition in the Supreme Court of the United States. The court agreed to hear the case to resolve the question of whether the right to counsel guaranteed under the 6th Amendment of the Constitution applies to defendants in state court. The lower court was the Bay County Circuit Court, 14th Judicial Circuit of Florida. The trial judge denied Gideon's request for a court-appointed attorney because, under Florida law, counsel could only be appointed for a poor defendant charged with a capital offense. The Florida Supreme Court agreed with the trial court and denied all relief. The issue involved a prior decision of the courts, Betts v. Brady, 316 U.S. 455 in 1942, which held that the refusal to appoint counsel for an indigent defendant charged with a felony in state court did not necessarily violate the due process clause of the 14th Amendment. The court granted Gideon's petition for a writ of certiorari, that is, agreed to hear Gideon's case and review the decision of the lower court in order to determine whether Betts should be reconsidered. The court reversed and remanded. In its opinion, the court unanimously overruled Betts v. Brady. The case was argued on January the 15th, 1963, and decided on March the 18th, 1963. Justice Black, who wrote a dissent in Betts, wrote the unanimous opinion of the court. Justices Douglas, Clark, and Harlan each wrote concurring opinions. The court held that the Sixth Amendment's guarantee of counsel is a fundamental right essential to a fair trial, and as such, applies to the states through the Due Process Clause of the 14th Amendment. In overruling Betts, Justice Black stated that reason and reflection require us to recognize that in our adversary system of criminal justice, any person held into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. He further wrote that the noble ideal of fair trials before impartial tribunals in which every defendant stands equal before the law cannot be realized if the poor man charged with a crime has to face his accusers without a lawyer to assist him.
Now, let's see how it all happened.
Which table? Which table? Which table? There were times in prison when I felt like my life wasn't worth a pile of change or the bottle of hooch that I was accused of stealing. But every man has a right to his dignity and due process of law. I was deprived of both when I had to go it alone to defend myself against a felony charge that carried a 5-year prison sentence. I couldn't pay a lawyer, and when I asked the judge for one, he said Florida law would not allow it. Today, because of me, if somebody like you is accused of a crime and you can't afford a lawyer, you have the right to a free attorney appointed by the court. They're called a public defender. You don't have to figure it out for yourself like I did. That didn't turn out so good for me. I'm Clarence Earl Gideon. I was born in Hannibal, Missouri, the same as Tom Sawyer. But I didn't have a Tom Sawyer childhood. My dad died when I was 3. My mom married a guy I couldn't stand. We were very poor when I was growing up. In fact, one night a burglar broke into our house and we robbed him. We'd eat beans for breakfast, we drank water for lunch, and we would swell up for supper. The man my mom married made me the family's scapegoat. So I quit school after the 8th grade and I ran away from home. I took on the life of a hobo and a tramp. My first run-in with the law was when my mom went away. I never really forgave her for that. The next day, I escaped into the country. It was extremely cold, so I stole some clothes from a local general store. The store owner caught me, and I was wearing all of the clothes that I had stolen. And that was the beginning of my career in the justice system. Today, they would say I was a homeless, at-risk youth, and there would be interventions and diversion programs. But in those days, I was called a juvenile delinquent and a drifter. Instead of high school, they sent me to reform school on a burglary charge. And when I was 18, I graduated to the big house for robbery, burglary, and larceny. Over the years, I spent time in prisons, in the prison systems in Kansas, Missouri, Texas, and finally Florida, all on charges related to stealing stuff. I never was violent. So in 1961, I was living in Florida working on car electrics as a mechanic. I did some gambling on the side to make ends meet. One night, a pool hall where I worked and ran a poker game was broke into. The owner says he found a cigarette machine smashed in and he was missing a pile of change, plus some crates of beer, wine, and Coke. Basically, I got grounded for a party that I didn't have. Can you relate? The next thing I know, I'm in court without a lawyer, even though I kept asking for one. I was an outcast from society facing a felony charge of breaking and entering with intent to commit petty larceny. They pinned it on me, and I got sentenced to 5 years in prison. But I didn't take it sitting down. It wasn't fair, and it wasn't right that I could lose my liberty without even talking to an attorney. I used the prison's law library to read up on the Supreme Court. You've got it good. You're learning about the courts now, before you need them. Well, 2 years into my sentence, as prisoner number 003826, I wrote a letter by hand on prison stationery to the Chief Justice, Earl Warren. To the Honorable Earl Warren, Chief Justice of the United States Supreme Court. Petitioner, that's me, alleges that prior to petitioner's convictions, the sentence for breaking and entering with intent to commit petty larceny, he had requested aid of counsel, that at the time of his conviction and sentence, the petitioner was without aid of counsel, that the court refused and did not appoint counsel, and that he was incapable adequately of making his own defense, in consequence of which he was made to stand trial. In my letter, I referred to another Supreme Court decision that I found in the prison library that I summarized this way in my letter. Counsel must be assigned to the accused if he is unable to employ one and is incapable adequately of making his own defense. I underlined that part so they'd be sure to read that. Well, the court agreed to hear my case, Gideon versus Wainwright. Wainwright, he was the head of the prison system in Florida at the time, and I won by a unanimous decision, 9-0. The Supreme Court said that in criminal cases, courts have to appoint an attorney to represent you if you can't afford to pay. My case is considered a landmark in American judicial history. The book, Gideon's Trumpet, tells my story, and in a TV movie, Henry Fonda plays me, although I am better looking. As I said, this all went down in the 1960s. John F. Kennedy was the president. His brother, Attorney General Bobby Kennedy, even took notice of my case. Thank you, Your Honors.
Breaking news. If an obscure Florida convict named Clarence Gideon had not sat down in prison with a pencil and paper to write a letter to the Supreme Court, and if the Supreme Court had not taken the trouble to look for merit in that one true petition among the bundles of new ones it must receive every single day, the vast machinery of American law would have gone functioning undisturbed. But Gideon did write that letter. The court did look into the case. He was retried with the help of a competent defense counsel, found not guilty, and released from prison. After 2 years of punishment for a crime he did not commit, and the whole course of American legal history has been changed. Attorney Robert F. Kennedy, November 11, 1963.
The Supreme Court appointed Abe Fortas, one of the most respected lawyers in the country, to represent Mr. Clarence Gideon at oral argument. As history would have it, Abe Fortas was later appointed to the Supreme Court as an associate justice. But as an attorney representing Mr. Gideon on the day of oral argument in 1963, his job was to reason with the court and help the justices come to a just conclusion.
Although it was before you were even born, it seems like yesterday when I appeared before the Supreme Court. Here is the transcript of what I said to the justices. Let me say this, if it pleases the court. If you will look at this transcript of the record, perhaps you will share my feeling, which is a feeling of despondency. This record does not indicate that Clarence Earl Gideon is a man of inferior natural talents. This record does not indicate that Clarence Earl Gideon is a moron or a person of low intelligence. This record does not indicate that the judge of the trial court in the state of Florida or that the prosecuting attorney in the state of Florida was derelict in his duty. On the contrary, it indicates that they tried to help Gideon. But to me, if the court please, this record indicates that no man, certainly no layman, can conduct a trial in his own defense so that the trial is a fair trial. I'm happy to say that the court ruled unanimously that the Constitution requires states to assure free counsel for the poor in every serious criminal case. And that set the wheels in motion for the development of a public defender system, the system that reaches across the nation. Public defender systems that make a difference for each of you, even if you never get in trouble with the law.
Later, we're going to talk about how the public defender system has an impact on you and on the lives of all law-abiding citizens. So I want you to think about that as we continue. Justice Hugo L. Black wrote the opinion for the court, and all of the justices signed on to it, making the decision unanimous. Let's hear his perspective.
I am Justice Hugo Black of Alabama. It's not often that the Supreme Court comes to unanimous opinion as it did in Gideon versus Wainwright. It is, to put that in perspective, ladies and gentlemen, another famous case of the Brown versus Board of Education was also a unanimous decision. All of the justices in the Gideon case were very clear, as I wrote in that opinion. Lawyers in criminal courts are necessities, not luxuries. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with a crime, he is incapable generally of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceeding against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. This opinion set the stage of public defenders' system in the states. The attorney who defended Mr. Gideon when he was tried again was Fred Turner. Mr. Turner dismantled the so-called evidence against Mr. Gideon in a way that a layperson could not. It only took the jury an hour to come to a verdict of not guilty. Mr. Turner demonstrated how important it is for the people accused of a crime to have legal representation. Even if they can't afford an attorney, the court must appoint one when the defendant is faced with a serious criminal charge, so that justice is served. And when justice is served, our communities also are served, and so is our society as a whole. Here's Mr. Turner.
W. Fred Turner was Mr. Gideon's court-appointed attorney for the retrial of his case.
I'm Fred Turner. The local district court appointed me to represent Mr. Gideon after the Supreme Court sent his case back to Florida for a retrial. When I represented Mr. Gideon, I knew my way around the courtroom. I had a role in more than 100 trials during the course of my career. But I'll never forget this one. Not just because the Supreme Court, it was a landmark Supreme Court case, but because it is credited with starting the public defender system across the nation. It is a system of dedicated and highly competent attorneys who are there to help people like you if you should get into trouble and can't afford a lawyer. I was quite impressed with Mr. Gideon's civic engagement, as one might say, as we might call it today. The fact that he did his own legal research while in prison, picked up a pencil and wrote a letter to the Supreme Court, shows that we as citizens have the right and the responsibility to engage with our justice system and keep it accountable. All of us, all of you, have a stake in a well-run justice system. In the wrong circumstances, you could be Clarence Earl Gideon, and you have him to thank for the public defender who would represent you. Later, you'll get to talk with some of today's public defenders, but right now, we're going to hear about and from a young man whose case opened up the due process, fair process rights of juveniles. His name is Jerry Gault.
A 15-year-old Arizona teenager in 1964 was charged with making an obscene phone call. Let's see what happened to him.
Basically, Gault applied the basic due process rights to juveniles. Here's a summary of what had happened. The facts. This is Gault, 387 U.S. 1, 1967. Thank you. Gerald, Jerry Gault, was a 15-year-old accused of making an obscene telephone call to a neighbor, Mrs. Cook, on June the 8th, 1964. I wanted to augment just a little bit so we really get a perspective of what happened there. So I stepped around my desk and I went to my shelves and I got a book, a real book. Young people, roll your eyes. I know you could get it on your iPad in just a few clicks, but people of my generation understand the value. And I'll just add a couple of sentences right here to put it properly in perspective. Part of the opinion and summary included this. The police action on June the 8th was taken as a result of a verbal complaint by a neighbor of the boys, Mrs. Cook, about a telephone call that made to her in which the caller or callers made lewd or indecent remarks. It will suffice for the purposes of this opinion to say that the remarks or questions put to her were of the irritatingly offensive adolescent sex variety. With that, we see that after Mrs. Cook filed the complaint, Gault and a friend, Ronald Lewis, were arrested and taken to Children's Detention Home. Gault was already on probation when he was arrested after being in the company of another boy who had stolen a wallet from a woman's purse. At the time of the arrest related to the phone call, Gault's parents were at work. The arresting officer left no notice for them and did not make any effort to inform them of their son's arrest. When Gault's mother did not find Gault at home, she sent his older brother looking for him. They eventually learned that of Gault's arrest from the family of Ronald Lewis. When Mrs. Gault arrived at the detention home, she was told that a hearing was scheduled in juvenile court the following day. The arresting officer filed a petition with the court on the same day of Gault's initial court hearing. The petition was not served on Gault or his parents. In fact, they did not see the petition until more than 2 months later on August 17, 1964, the day of Gerald's habeas corpus hearing. The June 9th hearing was informal. Not only was Mrs. Cook not present, but no transcript or recording was made, and there was no one sworn in prior to testifying. Gault was questioned by the judge, and there are conflicting accounts as to what, if anything, he admitted. After the hearing, Gault was taken back to the detention home. He was detained for another 2 or 3 days before being released. When Gault was released, his parents were notified that another hearing was scheduled for June 15th, 1964. Mrs. Cook was again not present for the June 15 hearing, despite Mrs. Gault's request that she be there, quote, so she could see which boy done that talking, that dirty talking over the phone, end quote. Again, no record was made, and there were conflicting accounts regarding admissions by Gault. At this hearing, the probation officers filed a report listing the charge as lewd phone calls. An adult charged with the same crime would have received a maximum sentence of a $50 fine and 2 months in jail. The report was not disclosed to Gault or his parents. At the conclusion of the hearing, the judge committed Gault to juvenile detention for 6 years, or until his 21st birthday, whichever came first. Gault's parents filed a petition for writ of habeas corpus, which was dismissed by both the Superior Court of Arizona and the Arizona Supreme Court. The Gaults next sought relief in the Supreme Court of the United States of America. The court agreed to hear the case, determine the procedural due process rights of a juvenile criminal defendant. The procedure in the lower courts, the proceedings against Gault were conducted by a judge of the Superior Court of Arizona who was designated by his colleagues to serve as juvenile court judge. The lower court ruling, the juvenile court committed Gault to juvenile detention until he attained his age of 21. At that time, no appeal was permitted in juvenile cases by Arizona law. Therefore, a habeas petition was filed in the Supreme Court of Arizona and referred to the Superior Court for a hearing. The Superior Court dismissed the petition, and the Arizona Supreme Court affirmed. The issue, the Supreme Court agreed to hear the case to determine the procedural rights of a juvenile defendant in a delinquency proceeding where there is a possibility of incarceration. And the final ruling, I have to actually change what's in the material here, it was reversed and remanded, okay? But it did not deal with Betts v. Brady. Now that was in Gideon. This case was decided by the U.S. Supreme Court, argued December 6th, 1996, decided May 15th, 1967, and it was reversed and remanded to the state of Arizona. There was a dissenting opinion by Justice Stewart indicating that generally the Supreme Court shouldn't get involved in juvenile matters. They should be left to the states, and that it would, in essence, open up a can of worms and provide these rights to hundreds of thousands of juveniles across the country. But that's what happened in Gault, and as it says, it was not a unanimous decision. Stewart actually dissented. In its opinion, the court underscored the importance of due process, stating that it is the primary and indispensable foundation of individual freedoms, and that the procedural rules which have been fashioned from the generality of due process are our best instruments for distillation and the evaluation of essential facts from the conflicting data that life and our adversary methods present. The court noted that had Gault been 18 at the time of his arrest, he would have been afforded the procedural safeguards available to adults. And the court closely examined the juvenile court system, ultimately determining that while there are legitimate reasons for treating juveniles and adults differently, juveniles facing an adjudication of delinquency and incarceration are entitled to certain procedural safeguards under the Due Process Clause of the 14th Amendment. It's very appropriate given what's happening in our juvenile court today.
Hey, I'm Jerry Gault. All the talk these days is about texting and driving on one of these things, right? Texting and driving. Well, in my days, it was all about making prank calls. One of these old phones, well, somewhat old phone. In my day, it was more the rotary phone, like What I'd be writing about is my case that went all the way to the Supreme Court, and I'd call it My Fight for Your Rights. Just a year after the Supreme Court decided Mr. Gideon's case, I got into just a little bit of a trouble with the law down in Arizona. It was the morning of June 8th, 1964. I was getting ready for work in my parents' trailer home, and my friend Ronnie Lewis was over. Y'all have a friend that maybe got you into a little more trouble than you should have gotten into when you were 15 years old. That was Ronnie. My buddy was over at my folks' trailer home where I lived, and he was in the other room. I'm getting ready for work, and I hear my man Ronnie talking on the phone, saying some pretty lewd, pretty obscene things. Raunchy language. So I walk over. Ronnie, what are you doing? Grab the phone from him, put it down, kick him out of the trailer. And the next thing I know, the county sheriff shows up and hauls me off to jail to be detained. I'm already in a little bit of trouble, so this isn't good for me. This isn't good. The cops don't tell me what's up. They don't give me my rights. They don't say anything. I hear later that the lady in the trailer park says she got a crank phone call. To tell you the truth, if she was standing right here in front of me today, I wouldn't know what she looked like. The Constitution says you're supposed to be able to confront your accuser in a court of law. That didn't happen in my case. She didn't show up for any of my hearings, even though she was asked to by my parents. But anyway, that night, my parents get home. Remember, I'm 15 years old, and they don't know where I am. They check my boss. They check my friends. They call the hospital, and they can't find me. Finally, they track me down. I'm at the county children's detention home. But they can't come get me. The officials there said, no, you can't come get them. The next morning, I land in court. No attorney, no parents, no rights, nothing. Just me and the judge. His name was Robert McGee. When it comes to deciding what to do with me, the judge says, you know what, I'm going to think about it. And he throws me back in detention for a few more days. And then a few days later, out of the blue, they just kind of let me go. Fine with me, right? I'm just going to keep my head down and live my life and move on. Well, that day, my mom gets a note from the superintendent of the Children's Detention Center telling her that the judge has set a hearing, a delinquency hearing, to determine what to do with me. And I'm thinking, what the heck? You know, one day I'm out of jail, I'm back at work, and then now there's a judge talking about reform school. Judge McGee, long story short, at this hearing, says that I'm a delinquent child and says, I'm going to send you to the state industrial school until you are the age of 21. Remember, I'm 15. That's 6 years. I was charged with making lewd phone calls. If an adult had been convicted of that crime, the adult would have gotten a maximum of 2 months in prison and a fine up to $50. I've got a prison sentence of 6 years. It's basically prison for kids, right? Basically prison for kids, 6 years. Looking back on it, what was obscene wasn't a phone call that my buddy Ronnie did, allegedly. What was obscene was the process. I wasn't ever told the charges against me. My parents were kept in the dark. No rights, no attorney, no transcript, nothing like what they call due process, doing things the right way. My parents ended up taking my case to the Arizona Supreme Court. That court decided that, well, because I was a juvenile, might have been entitled to some due process rights, but what this court did was okay. They let it stand. So we took it all the way to the United States Supreme Court, and I finally got justice. The Supreme Court ruled in my favor, 8-1. They said the trial court had done me wrong and that kids have rights too. Justice Abe Fortas, Rhodes College graduate, wrote the opinion. Remember, he was the attorney for Clarence Gideon. He wrote a great one-liner in the opinion, and I'll leave that with you today. He said, under our Constitution, the condition of being a boy does not justify a kangaroo court. That's my story.
My attorney, Abe Fortas, asked me to write down my story. So I wrote him a 22-page letter, as honest as I could tell it. I hope my kids read it someday so that they know what really happened to their old man. Here's the part I'd want them to remember about me. I always believed that the primary reason of trial in a court of law was to reach the truth. My trial was far from the truth. There was not a crime committed in my case, and I don't feel that I had a fair trial. If I had an attorney, he could have brought out all of these things in my trial. I believe that each era finds an improvement in law. Each year brings something new for the benefit of mankind. Maybe this will be one of those small steps forward. In the past 35 years, I've seen great advancement in penal servitude. Thank you for reading all of this. Please try to believe that all I want from life is a chance for the love of my children, the only real love that I ever had. And with that, I rest my case. The rest is history.